My guest today is Spiro Verras. Spiro is a Florida-based attorney whose legal practice focuses on estate planning, probate, wills and trusts, and elder law. He is active with the Tampa Bay Estate Planning Council and the Academy of Florida Elder Law Attorneys. And he's licensed to practice law in Florida, Louisiana, and Texas. Spiro, thanks so much for joining us today to share advice and tips all about estate planning.
My pleasure, Andrew. Thanks for having me.
I'd love to just start out just by learning a little bit more about your background. How did you get into practicing estate planning law?
You know, it's one of the things you kind of fall into where you were destined to be. I went to Yale undergrad and got a scholarship after I graduated to Tulane Law School. And I'd never even been to New Orleans before, but it was a great deal. And I graduated from Tulane, no idea what I wanted to do, but I was hired by a big New Orleans law firm. I was hired as a litigator, and I spent several years as a litigator, made partner. And then I actually grew up in the Tampa Bay area. My parents were older. I was an only child, and they were getting sick. So my firm had offices in Houston and New Orleans, and I convinced them to open a Tampa office. And so after I got here, my parents' friends asked me, "Oh, Spiro, you're back. Can you do?" I had to take the Florida bar, of course, and they said, "Spiro, can you write a will for us?" And so I started doing it, and realized that I really liked it. And I was still with the New Orleans firm until 2005, when Hurricane Katrina shut down the firm for over a year.
Wow.
And we all scattered. The partners moved to New York, California, wherever they had a family that they could go to be with. I was already out, and I had staff here in Tampa, so I had to very quickly set up my own company and open my own accounts and get payroll going, and I did. And I have been in solo practice essentially ever since, and focused since then entirely on estate planning. And as soon as I came back to Florida, I started taking every class I could, every seminar I could. I loved it, and it's not something that you dream of doing when you're in law school. When you're in law school, you dream of being in the courtroom with a really expensive suit and wooing the jury with your oratory. But I discovered that I like the counseling aspect of it, about sitting with people, learning what their needs are, and trying to identify the best plan for them.
Did you take estate planning classes in law school, or was this totally training on the job?
I did take estate planning classes in law school. They were required curriculum, though. It wasn't like I was taking the advanced electives, because again, I didn't think I was going to be writing wills for a living. It didn't seem very exciting to 23-year-old Spiro. But 53-year-old Spiro loves it. So I've had to learn as I've gone along all the more advanced aspects of estate planning.
Excellent. Well, I'd love to dive into some of what those aspects are that people should keep in mind. Estate planning is certainly one of those things that not everybody does it thoughtfully. Some people don't even do it at all, and it can really hit you when you need it. So, I understand sort of the wisdom is get things in place before you need it, so that when you do need it, everything's already ready to go. What are the elements of a good estate plan in general, in your view? And maybe it'd be helpful just to make it concrete for folks to use maybe 3 different personas to frame this. So maybe say a 25-year-old young urban professional, unmarried, no kids, working a professional job, but otherwise no real obligations, versus say a 40-year-old married professional, has kids, versus say a 65-year-old retiree, empty nester, etc. What are the elements of a good estate plan for, say, these 3 type of personas?
Well, at each stage, there are 2 fundamental segments to the estate plan. There is the portion of the plan that addresses what happens when you're alive, but unable to make decisions for yourself. And then, of course, there's the portion that governs what happens after your death with your property and with your family. And for the 25-year-old, it's the while you're alive part that's going to be more often the focus. Frankly, I don't get that many 25-year-olds coming to do their estate plan unless they are young parents, because young single 25-year-olds tend to feel like they're immortal and nothing will ever happen to them. But there are plenty of people also who have the wisdom to try and set up a plan before they need it, as you say. So for a 25-year-old, you're really looking at the long term. And that client is not going to know where they're going to be 60 years in the future at their likely life expectancy. So you're trying to set up something that will work, but you can't anticipate everything. So for example, a 25-year-old will typically name a parent as the executor, or in Florida we call them a personal representative, the administrator of their estate. A parent as their agent on a durable power of attorney, or as their healthcare surrogate or medical power of attorney, as other states refer to it. And those choices are going to shift over time, obviously. But the typical 25-year-old is focused primarily on things like a living will designation of healthcare surrogate. In Florida, we combine those documents, and it controls what happens to you medically and who can make decisions for you and speak with your doctors. Once we turn 18, our parents don't have those rights anymore. So I often have people in that 18 to 25 age group coming to me and asking, look, I want to make my mother my healthcare surrogate because I'm going in for some procedure, and she needs to be able to make decisions while I'm under anesthesia. Likewise, they'll frequently name a parent as their agent on a power of attorney. So, if you're traveling abroad, your mom can pay your bills for you. And they fear accidental death more than they fear the sort of natural death. So that they'll make a parent, they'll do a will if they're going to go to Patagonia for 3 weeks or something like that, and they want to make sure they have something in place. When you get to be middle-aged, the 40-year-old married professional with children, the focus usually there is the children, and guardians for the children. For example, most couples that come to me with young children, their primary decision is if something were to happen to both of them, who would be responsible for raising their kids? And then a separate, or it could be the same question, is who would maintain the couple's or the person's assets for the children until some specified age. And that age, can be 18, it can be 25, it could be 35, but the couple wants to make sure that if something happens to them, the appropriate persons are in charge of their child's welfare and in charge of their child's assets. And it's an interesting case, because if you're a young couple, most of us inherit from our parents or from the previous generation when we're pretty old in the United States. I mean, typically when I do a probate, the beneficiaries, who are the children of the deceased, are in their 50s or 60s or even 70s, because the parents were in their 70s or 80s or 90s. When you're a 40-year-old person, and if something were to happen to you soon, your children are going to inherit at a very young age. And sometimes people try and create trusts to protect the assets until their children reach a level of maturity that we all take different times to reach. And then finally, you get the senior, a person in their 60s or 70s who's retired or nearing retirement, and the children it's an empty nest. The children are out of college, out of grad school, married themselves. And for that person, it's, again, you return to the advanced directives as a key issue. So who is going to make decisions for me if I can't make them, or if my spouse can't make them for me? Who do I trust with those legal decisions, medical decisions, all kinds of decisions that may be, as we face our mortality, we realize they may be looming. And then, of course, assets. By the age in their 60s or 70s, most people have accumulated as much or as they're going to accumulate in their work lives. And then it becomes an issue of how to preserve the wealth that they've accumulated, how best and how least expensively to convey it to the people they want to inherit, and how much control they want to exercise over what happens to their assets after their death.
Got it. That's super helpful framing. And actually, I think the distinction you drew between how affairs are handled when the principal is incapacitated versus when they pass is a really important one. Do you find that clients of yours is the greater amount of focus on the incapacity scenario versus the passing away scenario, or vice versa, or about even?
You know, I would say the incapacity scenario interests people more. Yesterday had a call with a couple, and they came up with, I think, 6 backup healthcare surrogates, which in Florida is the person who can make medical decisions for you and can get your information. They have each other and each have 6 backups. They were really concerned with who would be making those decisions. Likewise, on their powers of attorney, they were really concerned. Their wills were simple. You know, we're leaving everything to our kids in equal shares, but they were very concerned with who would be making decisions for them, and they wanted to have complete control over that process.
Interesting. So you alluded to probate a moment ago, and I understand that probate is really the heart of what drives estate planning around probate. What is probate at a high level? Can you kind of help us understand the end-to-end process, ideally step by step? So like if I don't know about this and I just need an orientation, like when does it begin? What happens at each key step of the way, and when does it end? Assuming, say, the decedent has no will, no trust, no beneficiaries, no estate plan. So in other words, you're fully in control of, probate is fully in control of you, rather.
Right. So if a person dies and has any assets in their name that don't have a beneficiary designation or a joint owner who would inherit the assets automatically at the time of death, those assets are in limbo because they're titled to a dead person. And if that person doesn't have a will, the laws of the state in which the person resided prior to their death will control who inherits their assets, or if anyone inherits their assets, because there are limits on how far the laws will go to family. So typically it's the next of kin, which varies from state to state, but you're going to have to establish the family tree in order to determine who the next of kin is. In Florida, a person who knew the person well will be required to submit what we call an affidavit of heirship, which establishes who the person's next of kin are, starting with were they married? Did they have children? Who were their parents? Are they alive or dead? Who were their siblings? Are they alive or dead? Who were their nieces and nephews? Who were their aunts and uncles? Who were their grandparents? Now in Florida, the analysis stops with grandparents. If you can't find anybody, so if you were an only child of only children who have all predeceased you, at some point the estate will escheat to the state. It goes to the state of Florida. So there are situations, people are always afraid, if I don't have a will, the state's going to take my money. It can happen, it's rare. But that's the first step in the probate process, establishing that family tree. Then the court someone has to petition the court to open a probate because we have to deal with these assets. And that person can be a family member, a person who's inheriting. It can be a creditor, a person who is owed money by the deceased. And that person asks the court to determine the beneficiaries of the deceased estate. So that's the first step in intestate probate, an intestate probate being one where the person never prepared a will.
So an interested party initiates that process, it sounds like?
Correct. That's the legal term, is the interested party. It can be a family member, a beneficiary, or a creditor. And so then the court will have to appoint someone, usually the person who's petitioning for the probate, to serve as the personal representative of the estate. I use the term personal representative, which is used in Florida and many other states. Some states still refer to the administrator as an executor. Some states use the term administrator, but it's all the same thing. It's the person who is appointed by a judge to administer the estate of the deceased. And although the processes vary between states, there are some things that are similar. Florida has a very formalistic probate process. There are states that have simplified probates. Florida is rather formal. And so in this state, personal representative is appointed by a court. Typically will have to post a bond, which is like an insurance policy to make sure they don't make off with the assets of the estate or leave creditors unpaid. And then the court will issue to the personal representative what's called letters of administration. misleading. It's a deceptive term because it's one piece of paper, but it's the letters of administration. And that allows, the letters of administration essentially say that the administrator can do anything that the deceased can do with his assets. He's treated by law as if he were the deceased. So now you have somebody who can liquidate stocks and bonds and mutual funds and sell real estate and marshal it all together.
How does the court select this person if there had been no prior instructions or indication by the deceased? Like, how do they make sure that person is fair, so to speak?
That's an excellent question. And the way that Florida does it is a majority of the beneficiaries choose. It's by essentially a majority vote of the people who are inheriting. So it happens frequently. And there are some large estates where it's a big fight. It can happen, for example, in one of the cases in which I'm involved, a relatively wealthy man died quite young in his 50s, and he was survived by 3 minor daughters who were in the custody of his ex-wife, from whom he was very estranged. His daughters nominated their mother as the administrator of his estate. So his family was very upset by that nomination because they hadn't, he hadn't spoken to his ex-wife in years, and they were in bad terms, to say the least. And they tried to fight it, but the court ultimately determined that even though she was the last person on earth that the deceased would have wanted administering his estate and taking over his company and his house and all of his assets, and she made herself president of his company because she now controlled all the shares as the personal representative. And there was nothing that could be done. Florida law is absolute. The beneficiaries determine who will administer the estate. There are limits. A person who's been convicted of a felony cannot. A person who cannot be bonded cannot. So there are limits. A person has to be a resident in Florida of the state of Florida, or a family member. A family member can serve even if they live outside the state, but if a non-family member has to be a resident of the state. But other than those limits, the judge does not make a who's best for the estate determination. He's guided by what the beneficiaries choose.
Got it. So, and then what happens after that person's appointed and begins that process?
Right. The first step is to publish a notice to creditors in the newspaper. You want to do that as quickly as possible after the appointment, because that is the primary delay that people don't like about probate. In Florida and many states, anyone who was a creditor of the deceased or of his estate has 3 months from the date of first publication of notice of creditors in which to file a claim for what they were owed. It's almost like a bankruptcy. So you publish a notice and all the creditors have 3 months to come in and file claims. You can't, though, avoid creditors exist by simply putting a notice in the legal notices section of the paper. If you know of a creditor, you have to serve them by certified mail with the notice to creditors as well. So you have to serve all known creditors and publish for all unknown creditors. And they have those 3 months to file their claims. In the meantime, while you're waiting for the claims to be filed, the personal representative can marshal the assets, open an account in the name of the estate, sell real estate, sell stocks and mutual funds, consolidate the assets in one place is usually what happens. There are exceptions, like for example, in the example I just gave, the ex-wife was running the business because it wasn't, she was going to convey the business intact to her daughters. So those 3 months are used for marshaling the assets of the estates, inventorying them. So if you have to get an inventory of the property of the deceased, cars, the contents of their homes, and all of that, evaluations. So there is work to be done during those 3 months. At the end of the 3 months, the creditors have to be addressed. Anybody who filed claims, the personal representative has to get in touch with them and figure out whether they can try and settle the claim. There is also an option where if the personal representative doesn't feel if a claim is valid, she can object to the claim. And in which case, that puts the creditor in a position where they have to sue the estate to try and collect on the claim. So that's the creditor aspect of it. At that point, also, the personal representative has to submit an inventory to the court showing what assets she was able to identify and marshal what their date of death values were. And then after all the creditors are settled and all the assets have been inventoried, then only then can the personal representative distribute the assets according to the inheritance laws of the state.
Got it. So when you add up all these actions that have to occur, how long does the probate process take end to end? And I know it can vary. There can be short ones and really long ones. But what have you seen in practice?
As a practical matter, because of the 3 months, you're never going to go under 3 months. You're not going to go under 4 months because we file the petition. It has to be reviewed by the probate clerk. It has to be reviewed by an intake attorney, then sent to the judge who also reviews it. So that can take 3 to 4 weeks. So the personal representative might be appointed a month after we file the probate. Then we have to wait to 3 months. Then it's going to take at least a month to deal with the creditors and make the distributions to the beneficiaries. Assuming everything goes right, probate will take 5 to 6 months in Florida typically. It can take longer, but it really can't go below 5 months.
Got it. So that's best case scenario. And, I guess in a bad case, it can stretch out for years, I imagine.
It can. I mean, there are scenarios where, for example, a piece of property, the deceased owns something that's not readily marketable, and so that can cause delays. Or the deceased was involved in litigation, and the personal representative has to keep the estate open until the other litigation is resolved. In fact, in that situation, the personal representative is usually substituted into the litigation for the deceased. So there are cases where it can drag on for years. I have probates that are open now that go back 10 years because of litigation in one instance.
Got it. Okay, so one of the big incentives for having a good estate plan is that you can accelerate or sidestep probate and the attendant costs that are associated with that. Because as I understand it, probate is costly. It's not a free process. Can you comment on for folks who do not have a good estate plan, how costly is probate, and what are the sources of that cost?
So in Florida, probate fees are set by statute. Some states you can charge whatever you want. In Florida, you can charge whatever you want, but there's a presumed reasonable fee that you are automatically sort of entitled to, and that fee is based on a percentage of the value of the estate. It starts with a minimum fee of $1,500. So you can have an estate, and there are estates that have 0 assets, but there's a reason why you need to open a probate. Even though there's 0 assets, the personal representative is going to have to pay the lawyer at least that $1,500. Beyond that, it's basically 3% of the value of the estate up to $1 million, 2.5% between $1 million and $3 million, 2% between $3 million and $5 million. And it's a declining percentage above that I don't have memorized because I rarely have an estate that large that the person has not done a real estate plan for. So, God willing, they come as often as possible, but so it can be substantial. Even just $1 million estate, you're talking about a $30,000 fee to the lawyer. And the lawyer does a lot of work in probate, but there are certainly ways to avoid that. There are also court costs that typically court costs, filing fees, certified mail charges, publication of notice to creditors, posting a bond can run over $1,000 for a probate. And those are all in addition to the fees. In addition, if you don't have a will, the petition to determine beneficiaries and all of that first stage is excluded from the statutory fee. That's extra. That's an extraordinary fee. If creditors file separate suits against the estate, that's another extraordinary fee where the lawyer is supposed to charge hourly. And dealing with real estate, also extraordinary. So it can run up quite a high bill if you don't have a good estate plan in place.
All right, gotcha. For a decedent that does have their estate go through probate, what ways have you seen that probate can actually cause distribution outcomes that the decedent clearly would not have wanted or expected? I was just wondering if you'd comment on basically how intestacy laws, while they're meant to sort of simulate what the state's best guess is in terms of how the decedent probably would have, sort of air quotes, probably would have wanted their estate distributed, how that can actually get screwed up if, in certain cases. I was wondering if you comment, maybe you have examples from prior experience.
Absolutely. One example that comes to mind is a woman that had MS. And when she was diagnosed and started to become disabled by this terrible disease, her husband abandoned her. He left. No one knows where he went. He never reached out to her. But she had no assets. She was unable to work. She ended up moving with her parents. And shortly before her death, she was badly injured in an accident. And she was able to hire, her mother was able to hire a personal injury lawyer to pursue a wrongful death case. She actually died from the accident rather than from the MS. And since she was dead, I had to open an estate for her, and the personal representative pursued the case. The problem was she was still married to the guy who had abandoned her decades earlier. And under the laws of intestacy of the state of Florida, he was her sole heir. She was a childless person with a spouse. So under Florida law, he was her sole heir. She never thought she needed a will because she had nothing. She was on disability because of her disease and never expected that she would end up inheriting, she would end up with an estate with a $500,000 wrongful death judgment that ended up getting paid out to her good-for-nothing husband, who she never divorced. So that's one example. The case of the gentleman with the ex-wife is another example. I mean, his ex-wife is still running his company. I'm sure if he had taken the time to prepare a will, and it remains a mystery why he didn't, that would not have been the outcome that he would have predicted. So you really, even if you have nothing, you should at least have a will, so that the person you hate most in the world is not in charge of your family and everything that you own after your death. You never know.
Okay, perfect. That's a real rallying cry to make sure you at least do the basics, at least have a will, and appreciate your sharing the examples. And that's actually a really good segue into wills. I'd love to, get some of your deeper thoughts on this. So I think most people will intuitively understand that a will is a document, you write specifying how you want your belongings and estate to be distributed when you die. At what point in one's life does it make sense to write a will and have a will?
In my opinion, you should write a will early. That 25-year-old should do a will. You don't want to be intestate, because we don't have in the United States sort of a central registry of family. And there are states in which it's much harder to prove. For example, in some states, that affidavit of heirs that says your family tree can't be written by one of your heirs. It has to be prepared by a third party who's familiar. I mean, what third party is going to know, my grandmother's name? That can be a real roadblock to establishing who your heirs are. Again, there's a possibility in many states that your estate ends up going to the state rather than to who you want it to go to. And many of us aren't really that close with our families too. I mean, our society is somewhat different than more traditional cultures, where people's friends are their family. And so that you don't necessarily want your next of kin to be making decisions for you or inheriting what you've worked for.
Do you recommend that, like, pretty much as soon as you reach majority age, 18 in most states, that you write a will then, even if you have nothing?
I recommend it, like for using the case of that the woman as an example. I mean, she had nothing. A will would have been helpful and would have avoided another outcome. Now, as a practical matter, I can count the number of 18-year-olds that I've written wills for on one hand.
Yeah, most of them can't even get through the DMV.
And usually their parents drag them kicking and screaming to my office to do, a basic estate plan. So it's just not something that's on your mind at that age. At 25, you start to get a few people in. Primarily, though, it's not the example that I gave earlier. It's young married couple in the 20s. They've had a baby, and now all of a sudden it's like, oh no, I don't want your mother to have custody of our baby if something happens. And there's this sort of that dynamic. But they need it. They do need it. Once they have a child, it becomes increasingly important.
Okay, perfect. So once you have a will, how does the probate process now shift? What steps of the process change, and how is it accelerated?
It's the initial stage is simplified and accelerated, as you say. The will establishes who will be the personal representative. It doesn't matter what your heirs think. If you say this person is going to be the administrator of my estate, your beneficiaries don't have a vote on this. The other difference is that you don't have to establish the family tree. The people that you say in your will are going to inherit are the people who are going to inherit. The judge doesn't care what your family tree is or whether your grandmother died in 1957. None of that is relevant at that point. So it really does simplify the process. You file the petition, then the intake attorney doesn't have to go through this, oh wait, they did the analysis correctly thing. And it speeds up that initial period. Probably that month that I said, that's usually when there's no will. That's usually when there's a will. If there's no will, you're looking at 2 or 3 months probably to establish. I have one now where I'm the administrator because the person died. He was an only child. He was never married, no children. And his condo association basically hired me to administer his estate because he had died and the condo fees were being debited from his account. And then they ran out of money in the account. And so they said, somebody has to do this probate for this guy because the condo's in limbo. And I've spent a year trying to establish his family tree because I found people on one side of the family, but they know none of the people on the other side of the family. And so I finally found the other people. So you can really shorten that initial period down to 3 to 4 weeks if you have a will. Then, obviously, the judge's job is easier. You just have to follow what the will says. All the court is looking at is to confirm that the personal representative is executing the will as it was written. It simplifies the process. That's when you can do a 5 or 6 month probate. If you have no will, you're not going to do it in 5 or 6 months.
Are you still having to do the 3-month notice to creditors, even with a will? Yeah.
You do. That's unavoidable unless you have a trust. Unavoidable.
And they get paid out. The creditors get paid out first before the remainder gets distributed.
Absolutely. And that can really cause unintended consequences. So, for example, the way that wills are interpreted, you have special bequests. So you say, I'm leaving my car to my son and $50,000 to my daughter and all the residue of the estate to my spouse, which is everything else. And you think your estate's big, but because creditors get paid first, if the estate is depleted, your spouse could end up inheriting much less than your daughter. So you could end up with, you had $500,000, but you ended up in a nursing home that was a gigantic creditor in your estate. And your son gets the car, your daughter gets the $50,000, and your spouse ends up with $10,000. So creditors can affect the outcome and can thwart the deceased's intentions.
So for folks who write their own will themselves, this is not uncommon. Obviously, you could probably do it more accurately if you have legal counsel representing you, but a lot of people will write their own will, maybe even just on a handwritten on a piece of paper. Just various ways people do it. What do folks need to know to make sure that they actually have a valid will in terms of the legally required formalities? What are key gotchas or issues that commonly trip up people who are writing their own wills?
So that's an excellent question. You really need to know the formalities in your state because they vary dramatically. So for example, in Louisiana, what you described, a holographic will, one written in your own handwriting and signed by you, is valid. In Florida, it is totally not valid. In Florida, every will has to be signed in front of 2 witnesses who are disinterested parties. If the will is not self-proving, in other words, there wasn't a notary involved with certain other formalities, the witnesses have to physically appear at the courthouse to swear that they saw the person sign the will. So those formalities need to be followed. And obviously, if you do a will with an attorney, they will be followed in most cases. And so that's a critical part. Another thing that is an issue, that there are many reasons to see a lawyer, but I'll give you an example that's sort of Florida specific. Florida, as many people know, has tremendous homestead protection. You can owe a fortune in debts, your Florida homestead cannot be attached by your creditors. And there's no limit on the value. I mean, it can be multi-million-dollar home. If it's your Florida homestead, the only entity that can touch it is the IRS, the federal government, because the
I was
federal
about
law.
to say, yeah, they'll go after you for every last dime.
Yeah, they can bust the homestead, but any other creditor can't. So O.J. Simpson famously used that technique after his ex-in-laws, and the Goldman family got a humongous judgment against him in Los Angeles. He sold everything he had and bought a really expensive house in Miami and declared himself a Florida resident, and he was untouchable, even for the 17 years that he was in prison in Nevada, because he had the intention of returning to Florida. Florida courts refused to allow a lien to attach to his house. And that exemption passes beyond the grave. You can owe a fortune in debts, drop dead, and as long as you leave your home to your heirs at law, family members, your creditors can't attach it in the probate. It passes exempt, except if your will says, I direct that my home be sold and the proceeds be distributed to my children. People like that because your kids don't like each other. They don't get along. You don't want them co-owning a piece of real estate. So people often will write that into their wills. Bad idea. If you do that, it becomes non-exempt and your creditors can grab that asset. And so that's one of the reasons, obviously speaking to a lawyer is important. Those sorts of gotchas that you might not think about are very serious. Another issue is if there's any possibility whatsoever that somebody could challenge your will, you need to go to a lawyer. Because when I've had to testify dozens of times at this point, defending wills that I wrote, basically saying, no, grandma knew what she was doing when she disinherited you. She was totally competent, and nobody was unduly influencing her. I met with her privately. She told me her wishes. She told me her reasons. And their case basically gets thrown out because I don't have an interest in the outcome of this. I'm just telling you what happened. So that's critical. If there's any possibility whatsoever, I know I like doing things from home too. I mean, I shop online, I book my travel online. It's worth putting some clothes on and going to the lawyer's office for a number of reasons.
Gotcha. Hey, I was just curious, in the kind of example that you just gave there, do you recommend that those type of conversations typically be like even recorded? I know they don't have, they're not sort of evidentiarily required in court, but they may have some persuasive authority. Do you recommend that these type of meetings be recorded so that you have more than just somebody's word, even if it's a neutral attorney?
Yes, if there's some sort of extreme deviation from what the expected distribution would be, I usually do like recording it. People don't feel comfortable with it, and so I won't do it. But there are some situations, and I consider prenuptial agreements part of an estate plan sometimes, because most people don't stay married to the same person for the rest of their lives, so they have kids with one person, then they get divorced and they marry somebody else and they still want their kids to inherit. So they do prenups as part of their estate plan. And I do like to record those if there's a substantial estate, because that's always an issue that's brought up. And I'm not a divorce lawyer, but I hear the horror stories. So if I can do a video, that's great. As I said, for normal estate plans, unless there's a deviation from what would be expected, where say, you're suddenly changing an estate plan that was in place for a long time and a child who was expected to inherit equally is being excluded. Obviously, you'll tell me the reasons. I'm going to put them in my notes. They're going to be in my file, but having you saying it on video is very persuasive.
Got it. And I know this is specific to Florida because of the example you just gave, but in the example of like the homestead having almost an absolute shield in probate. You mentioned if the will directs the home to be sold, not exempt. If the beneficiaries just independently, separate and apart from the will, sell it later, that would be still exempt, right? Because it had already passed.
Correct. The way the Florida law sees it, and it's like this, there are textbooks and treatises written on Florida homestead. This is an issue that's fascinated Florida lawyers for decades. the way the current understanding is from the Florida Supreme Court, the homestead, using the terms that they use in the opinions, inured to the heirs at the moment of the decedent's death. So it never went through probate. It was theirs at the instant the parent died. Typically it's the parent. And so it was never available to creditors. It became theirs, and the creditors have no claim against them for it.
Makes sense. Okay. And then more broadly, is there any other advice that you have or common problems that you see when people try to draft their own estate planning documents, whether it's, you know, a will or other types of documents?
Yes. One example, I've seen so many examples of incomprehensible wills that I've had to sit there with the judge and try and figure out what this says. But one that we recently wrapped up was a decedent had drafted as he was dying. He had cancer and he knew that he was dying, and for some reason did his own will, even though he owned quite a bit of real estate and had some substantial assets and was living with his girlfriend. And he said the will had special bequests, and it said, all the property located at, say, 123 Main Street to my girlfriend. And the next bequest said, the property located at 123 Main Street in equal shares to my children. So, you know, it was hard to understand what that meant. What I was able to infer was that he meant the contents of the property to his girlfriend. That's where they live together, and the real estate itself to his children. But that's sort of in ambiguity. I mean, but for the fact that the girlfriend consented to that interpretation of the will, the court would have had to give her the house, because all the property located at 123 Main Street means everything, including the real estate. And so it was only because of her, you know, desire to honor his wishes that we were able to actually clear that up in a way that everybody was happy with. But that sort of mistake happens all the time. You have to be very careful about clarity. People frequently do their wills online, and they're being interviewed, and they'll see that the question usually is, who do you want to inherit the residue of your estate? And they leave it blank because they don't think they have any residue. The residue is a legal term for everything else. And so that is a big question to leave blank. So you have to be don't leave anything blank. If you're doing it online, there's a reason why they're asking you that question. But there are just very common problems that lead to a big mess in interpreting. It's really strongly advisable to just see a lawyer for a will. It's a very important document.
On this topic, how do you evaluate a good lawyer for somebody who's not a lawyer?
It's tough. You know, when I was a litigator, I was a very sort of kindly litigator. I was not a pit bull. And you know, there were other lawyers at my firm who were pit bulls. They were so aggressive. They were ready to go to battle from the moment, you know, that they walked in the courtroom. I've always been you get more flies with honey kind of a guy. And also it just doesn't suit my personality. And so there are a lot of good lawyers. I mean, most lawyers are good. And I mean, there are exceptions, but most lawyers know what they're doing. Most estate planning lawyers know what they're doing. It's about a personal fit. Does this person, is this the kind of person, because you're gonna have to reveal to me all your personal business. Like, why are you disinheriting a child? Or what are your goals? What are your real goals in life? What do you want to happen when you retire? And all of that. So you have to have a good personal relationship. I consider most of my clients friends. We've spent so much time together. Typically an estate planning intake appointment takes 2 hours. I mean, it's a lot of time. And so, you know, I think it's all about personal fit. Obviously, there are credentialing. You want someone who's active in organizations. Like I've become an estate planning geek over the last 20 years. I mean, I joined every committee, every group, and I'm fascinated by sort of the more esoteric questions, but also, you know, developments in the law. and that's typically, I mean, I consider that a good sign that you actually, I would like my doctor, for example, to kind of be interested in medicine. So, I don't, I think it's good. You should look for somebody who's involved in law. And then, yeah.
Okay, excellent. So that was a great, I think some great advice about wills. I wanted to shift to talking about trusts. At the risk of sounding obvious, what is a trust? How does it differ from a will? How should people think about the differences in goals between setting up a trust versus just having a will? Like, how do the goals differ between these two instruments?
So there are a number of different types of trusts, but in terms of your question, I think we're talking about what we call a revocable trust, also called a living trust. A grantor trust, for example, another word. The term means it's an entity that you create while you're alive that serves as the owner of your assets. And it can, in terms of taxes and for most legal purposes, a revocable trust is disregarded. So it's not protection against creditors. It's not a separate entity in the sense that an LLC or a corporation is a separate entity. But for purposes of probate, it is very effective. What it does is, because the trust owns assets, when you create a trust, one of the important parts after you create a trust is putting assets in the trust or making them go to the trust on your death. If you fund it properly, if the trust either owns or will own upon your death all of your assets, there is no need to probate your estate, because you may be dead, or I'll make myself the dead person. I put my house, my mutual funds, the stock in my corporation, I retitled that all to the Spiro Verras Revocable Trust. Then I die, Spiro Verras Revocable Trust still exists. There's nothing that's titled to a dead person at that point. And say my successor trustee, whoever's named in my trust to take over the reins upon my death or disability, can take over right away. Give a death certificate to the bank, give a death certificate to the brokerage that has my mutual funds, and can immediately liquidate them. Can record a death certificate in the official records and immediately sell my house. So the trust avoids probate, avoids the fees associated for probate. I mean, if you have a trust, you don't really, a fully funded trust, you may not need a lawyer at all. Your heirs, upon your death, they can administer it themselves. They can hire a lawyer if they want help, but they don't necessarily, there's no court proceeding that's required. So it's primarily structured to avoid probate. Now, that being said, I like to do a probate also, just for the creditor protection, because by publishing notice to creditors, you block any creditors from coming along later. So it's worth possibly, that's either zero value probate where it's $1,500. It may be worth the $1,500 for peace of mind purposes, because by publishing notice to creditors, if they don't file a claim in 3 months, they're forever barred from pursuing the estate or the heirs.
I see. So it is, if you have a validly implemented trust, it is not a technical requirement to ever set foot or file any paper in a probate court, but it might be strategically wise to do that for the creditor reason you just mentioned. Is that an accurate summary?
Correct. Yes, that's right.
Gotcha. I was curious when you mentioned that it's important to have, fund the trust to validate that it's a properly created trust. Does that mean that, like, I have to go and re-record real estate at the county clerk's office in the trust name? I have to go and send certified documentation to my mutual fund company to retitle that account in the trust name, et cetera? Or do I just set my beneficiary to be the trust? Or in the case of real estate, do I really need to retitle that asset, et cetera? Will that actually invalidate the trust if I don't do those things, et cetera?
It'll reduce the value of the trust if you don't do those things, because when I do a trust, when I create a trust for a person, I also create what we call a pour-over will. A pour-over will is a will, the beneficiary of which is the trust. So in case I forgot to put something in my trust while I was alive, the pour-over will probate it into my trust. And there are unexpected things that can happen. Alanis Morissette, the guy who wins the lottery and dies the next day, he's not going to have time to fund his trust. I mean, so he might have had a perfectly funded trust, but he won the lottery. You need a probate to get that money into the trust. So but any assets that you are aware of should go into the trust. For a long time here in Florida, we were very scared about putting homesteads in trust because we were afraid of impairing that absolute protection against creditors. But there have been statutes enacted by the Florida legislature establishing that the homestead is protected even if it's an irrevocable trust. And there have been cases in the Florida Supreme Court repeatedly that achieved the same, that said the same thing. There was one unfortunate opinion out of a bankruptcy court in Miami that suggested otherwise, but virtually unanimous in Florida, in the Florida legal system, that the trust, it's wise to put the home into the trust. And other real estate as well. And typically the lawyer who prepares the trust should convey all real estate owned by the grantors into the trust. I mean, the lawyer should prepare the quitclaim deeds, get them recorded. Now, you have to be careful about trusts because there are, I've had to do many probates where a couple was invited to some dinner at BT Bones by a lawyer, free dinner, and learn about trusts, and they paid, $1,500 for a trust or some, relatively small amount for a trust. And they, the lawyer it was a template trust. You have to fill out a form, they get it ready for you to sign, you go to the office and sign it, and you give them the money, and that's it. They didn't put any assets in the trust, and they weren't instructed to put any assets in the trust. The person dies, and the daughter comes along and says, wait a minute, why do I have to pay you to do a probate? Your mom's assets weren't in her trust. So it's important because you end up in a position where you have to probate anyway, and you pay a substantial amount of money to create a trust. Everything should go in. It is a hassle, and a lot of people don't do it until they're older because they don't want the hassle of putting your home in your trust and your brokerage account. You hit on something which is actually a good strategy. Rather than retitling your accounts, you can make them payable on death to the trust, or name the trust as the beneficiary of your IRA, for example. And that avoids having to change title on things. It just, those things, instead of paying out to people, will pay out to your trust.
Got it. So it sounds like the really right way to do it is to actually go through the hassle on some time scale to officially retitle assets like your bank brokerage accounts, your real estate, et cetera. That would be the really right way to do it. Is that a fair statement?
Yeah, I think that's fair. Absolutely.
Well, how do you handle, personal property? Like, if I, as the principal, want to put literally everything I own in a trust, how do I put my iPhone in a trust? I never titled that anywhere. So that, maybe I have a strategy of like, I want to put a nominal amount in the trust, so to satisfy the formalities, and then I'll retitle my home later, or I'll do the bank and brokerage accounts later. But I just want to make sure my trust is up and running. Maybe I have a pour over will as well, so I'm guarded on that side. How do I verify that I can fund the trust with at least something nominal, even if it's personal property? How would I the mechanics? How would I do that?
When I prepare a trust, like a revocable trust, I always also include an assignment of all property to the trust. So personal property can be conveyed because it doesn't have titles. So just you can just say, I'm putting all my personal property in the trust. It doesn't require any registration, doesn't require recording. And so that basically says all property that I can retitle, I am retitling to my trust. And that's enforced by the courts. Basically, the courts will say that property is in the trust.
And that would be sufficient, right, to at least create a valid trust, if I just have that clause in the trust agreement itself?
Absolutely, yes, that'll do it.
Okay. For somebody who did that approach and did not go through the hassle, at least when they were alive, of retitling more consequential assets like your home or your brokerage accounts, but they did have a pour over will that said, upon my death, anything that I may have missed should automatically get poured over into the trust. Does that person in their lifetime need to go through that hassle of retitling in that case, or does that pour over will pretty much guard them?
By doing it that way, by not retitling during your lifetime or making accounts payable on death, not, can't do that with real estate, but with bank and brokerage accounts. You will still have to probate those assets after the person dies. So you're not going to avoid that dreaded 3% that the lawyer gets. And so that's most people who come to me, most people who opt for a trust with me do so because they don't want their children to have to pay some lawyer $30,000 to probate their estate. So by not funding the trust during their lifetimes, they are not achieving that goal.
I see. Gotcha. Okay. So it's a cost consideration, not a sort of legal impact or legal consequences decision. It's really a cost consideration.
Primarily cost, also the time delays. You also have a situation where, like, for example, I mean, using myself as, I usually with clients use myself as the dead person, just to avoid jinxing anything. And so I own a law firm. It's a corporation. If I have my shares titled to myself, it could take 5 months before my personal representative can sell the firm, do anything with the firm. That's a long time to have nobody, you know, able to manage and when my personal representative is not a lawyer, you can't do anything. He has to sell it right away. So that's an issue. You want, the delay can sometimes be a big consideration and a big motivating factor for the trust in addition to the cost.
Okay, cool. So tactically, how do you actually create a trust? Like, what are the key legally required formalities to have a valid trust? And, you know, what common mistakes do you see people sometimes get in trouble to when it comes to having a valid trust?
Again, one of the things that that people will say in their trust document is that everything's going to be sold. Again, if your homestead's in the trust, don't say that. You don't want to say that because you want the home to go. You don't know what might happen the last years before your death. Nursing homes are very expensive, and so you can, and it becomes a big creditor issue. So that's one thing to look for is don't require immediate liquidation of assets. Give as much flexibility as possible to your successor trustee. I give them absolute and uncontrolled discretion. That doesn't mean that they can run off to Tahiti with all of your money and not do what the trust says. It just means you don't second guess their decisions, because every beneficiary thinks that you sold dad's shares on the wrong day, creates problems, and you want the trustee to have as much discretion as possible in administering the trust. And as much flexibility in administering the trust as possible. So, like for example, sometimes people will have one child who they feel is not responsible with money. So in their trust, let's say they have 2 children. So son A gets his half of my estate outright. The trustee shall hold the other half of my estate in trust for son B for the rest of his life. And then they'll make son A the trustee for son B. And that's a nightmare. So because you're going to be having your brother calling you, asking you for money for the rest of his life. So, you want to give the trustee the flexibility to be able to resign and say, you know what, we're making this bank your trustee. You can deal with them. And that sort of thing. You want to create as much flexibility because trust can do a lot of wonderful things. I mean, if you have, say, a disabled child, you can have their assets be governed by a supplemental needs trust that allows them to qualify for benefits without being disqualified because they inherited something from their parents. There are a number of things you can do, but you want to give the trustee the flexibility to do all of those things. And so I build in as many of those provisions as I can.
Got it. What are legally required formalities that folks will need to observe?
In Florida, the trusts have the same signing formalities as the will. You need 2 disinterested witnesses and a notary. And the trust is an unusual document. It's like a contract between the grantor and the trustee. It's a trust agreement. So the trustee is agreeing to maintain the assets of the grantor according to the terms of the trust. And the terms change. When the grantor is alive, it's one set of terms. When the grantor is dead, it's a different set of terms. And the trustee will, both of them have to sign. So you can't just have the grantor sign. Usually the grantor and the trustee are the same person or people, but If they're not, you got to get your trustee into the room to sign that he agrees to all this. So that's a very important formality. Otherwise, it's the same as wills.
Got it. Okay, cool. So we talked a little bit about how trust can help protect wealth by reducing probate costs, by averting, sort of beneficiary, so to speak, infighting. But I also understand that trusts have maybe an advantage over wills in that they can provide anonymity. They can help minimize estate taxes. I was wondering if you could comment on how a trust can accomplish these things and why a will can't accomplish the same.
Sure. So traditional revocable trusts really are only able to avoid probate and speed everything up. But trusts come in a number of different flavors. And so irrevocable trusts are especially powerful because when you convey something to an irrevocable trust, you no longer own it. And so it's not an asset of yours that's available to your creditors. A revocable trust, in the eyes of the law, when you convey an asset to a revocable or a living trust, you still own it. An irrevocable trust has its own tax ID number. It's a separate entity from the grantor. And over the years, estate planning lawyers have become very clever in making irrevocable trusts that aren't entirely irrevocable. You can still change them in the decanting provisions and all kinds of things that allow us to, or trust protectors, basically making your lawyer the trust protector, which means you can basically modify the terms of your trust at your instruction in the future. And so these sorts of provisions, so it's not as scary as it used to be, but they can protect your wealth because they protect you. They can provide asset protection. They can't allow you to, if I'm being sued by a bunch of people, I'm not going to be able to say, oh, I put all my assets in an irrevocable trust, not mine anymore, and you can't touch me. That would be it. That would be considered a fraudulent conveyance. But if you did it in advance because of other reasons, and then you got sued, that would not be a fraudulent conveyance. So it can protect your assets from potential creditors. It can provide anonymity. A lot of wealthy people or people who are well known in Florida use land trusts. And Florida, we have a law, Florida in the Sunshine. Basically, everything about all of us is available online. You can, go to the county tax records and see what all your neighbors paid for their houses, and everything is very public. Other states, not so much, but Florida is extremely public. I'm not California. I can never find anything in California on real estate records, but Florida, you can find anything you want. I've had clients come in and ask me, why did you have such a cheap house? They've already stalked me before they met me. So it's annoying. And if I were a celebrity, if I were Tiger Woods or something like that, it would be really annoying because they can also find my address and show up in front of my house. So a lot of people use land trusts primarily for anonymity purposes. A land trust, the only thing it's identified, so it's, typically it's the lawyer who's the trustee, the person's lawyer. So it'll say, you look up my address and the address for my client for the land trust, and it'll say Spiro J. Verras, Esquire, trustee of the ABC Land Trust. And so when you try and look at places like Worth Drive in Palm Beach, it's actually kind of fun to do. And I had to do it one time because I was trying to find a defendant. Every house is in a land trust. You can't find, Rose Kennedy's house on the Palm Beach County property appraiser's website. And so that was an interesting, that's a way of providing anonymity. Estate taxes are, and it's become less of an issue because the current lifetime gift and estate tax exemption is $11.5 million for an individual, double that for a married couple. So that excludes 99.9 something percent of us on our deaths. We do not die that rich, but some people do. And for my clients who will, irrevocable trusts of a variety of natures provide one of the key strategies for minimizing estate taxes. You can gift a certain amount every year, currently around $14,000, to an infinite number of individuals, and you don't have to file an information return with a gift tax return with the IRS. By doing that and using that to fund irrevocable trusts, over time, you basically can deplete your assets, they still go to your beneficiaries as you intended, but you can use the irrevocable nature of the trust and gifting to those trusts, among other strategies, to reduce your estate taxes. A will can't do any of these things.
Got it. Do you have to have an irrevocable trust for anonymity, or can a revocable trust also provide anonymity for you? Because like you don't like register your sorry, did I say well? You don't register your trust anywhere.
Well, if you don't have real estate, you can get some anonymity with a revocable trust, because you don't have to name. I don't have to name my trust the Spiro J. Verras Revocable Trust. It can be called the Babadook Trust or something like that. But the problem is that when you have real estate owned by the trust, in addition to deeding the property to the trust, it's prudent and really very wise to record a certificate of trust in the public records. The reason that's important is that, say I have a son and he's my successor trustee. I title my home to my Babadook Trust, and then, that's great. But when I die, who's going to establish who my successor trustee is? So I usually record a certificate of trust that only contains the successor trust provisions, but it will have to say, on September 25th, 2020, Spiro Verras created the Babadook Trust with himself as initial trustee. The trust is currently in existence. Upon Spiro's death, his son becomes the trustee. That's great, because when I die, my son can take a death certificate, record it in the official records, and he has a clear ability to sell the home. But that loses some of the anonymity. That's part of the problem. Land trusts are really the only flavor of trust that don't require that sort of recording, because you never identify the grantor of the land trust. And that's probably, for real estate purposes, the most anonymous. And that's really where the anonymity comes most into play, because of the public nature of real estate records. You can't really look up to see where my Merrill Lynch accounts are. But my house, you can, Google me, and there I am.
Got it. Are land trusts irrevocable or revocable?
They're irrevocable, but because of the fact that the trustee has tremendous flexibility and is usually the lawyer for the grantor, they can be decanted. So, for example, if I own a piece of real estate in a land trust and I sell it, my trustee is usually, the way I prepare it, has the ability to decant the proceeds into a different trust or into any other entity he wants. So he can give it back to me. So even though the trust itself can't be revoked, assets can be moved in and out.
Got it. Okay, great. So what are estate planning considerations that the following types of folks should be thinking about especially? So I had three sort of personas in mind, if you will. One is, real estate rental property owners. A second is owners of family businesses or professional services practices like legal practices or medical practices. And a third is owners of very sizable stock holdings. Maybe they had company stock options, which is common in the tech industry, for example. Maybe the company had an IPO, et cetera, and they suddenly get a really big windfall. What are estate planning considerations that these type of folks should be thinking about?
So real estate holdings are important. If you own rental real estate in your own name, it creates liability problems. If there is an injury or an accident on the premises, the principle of premises liability would hold the owner liable. So owners get sued all the time because someone slipped and fell on a piece of property. Obviously, you can deal with that to some degree with insurance, but for the most part, I recommend that people put their rental real estate into a separate entity that they then own, typically an LLC, simply because it's easier. And it's a bit of a hassle. You have to file an annual report. You may have to file a separate tax return for the LLC. But the protection that it provides is great, because what it does is the LLC only owns that piece of real estate. So the most that a judgment creditor can get is that piece of real estate. They cannot get through the corporate veil and get any of your personal assets. So that's usually what I recommend for rental property owners. I have a number of clients who retired to Florida and bought like a strip shopping center, strip mall, with the proceeds of the business they sold up north. And I recommend very strongly to those people that they put them in an LLC. Current owners of family businesses and professional services practices like mine are it's a difficult situation. You obviously want it to be in some sort of a corporation. You do not want to be a sole proprietor of a business that has potential creditors. So if a lawyer makes a terrible error and gets sued, the lawyer's liability should be limited to the assets of his firm and not his personal assets. So and doctors and then everyone is the same. Obviously, insurance is also important for that, and every professional should carry adequate liability insurance. But beyond that, when you have a family business, there's succession planning. So you may want to establish in, say, the operating agreement of your LLC, who's going to inherit if one of the members dies. I try to build that in. It avoids probate. It's private. There's no public record of LLC operating agreements. So you can do a lot of estate planning for business owners using the corporate documents to allow for the succession of the business to the people you want to inherit it, and excluding the people you don't want to inherit it. That's an important consideration. With regard to people with sizable stock holdings, that's primarily more of a wealth and asset protection consideration. There's no liability in the sense that the real estate owner and the business owner might be liable. I mean, if I own stock in Apple, just because Apple gets sued, I'm not going to get sued. I'm fine. But if I own a lot of stock in Apple and I get sued, then I get sued by somebody else. They're going to go after that stock. That's where irrevocable trusts come into play. You may want to title your shares to an irrevocable trust that will go to your children, let's say upon your death or disability. You could do that, and there's unfortunate tax consequences to that. Trusts are taxed at a higher rate than people, and irrevocable trusts are among those trusts that are taxed at a higher rate. Revocable trusts are not, that just flows onto your personal return, but irrevocable trusts are tax worse. But the asset protection is great by placing assets of, if you have substantial wealth, that's a consideration. Another consideration is placing that wealth in a family limited partnership or limited liability company. That's a way of making your entire family actually and their wealth protected from everybody's creditors. And it's a very powerful tool. And I don't know if you want me to go into that, but it's a very effective way.
Well, I guess at a high level, I think what I'm taking away is that estate planning is more than just wills and trusts. It can start to touch upon things like corporate formation documents or governing documents, partnership documents, etc. Just in that last scenario that you painted, I was just curious if how does in the family example you gave, how does that family create an LLC without having a business purpose? Like, they're not, say, running a company, but they're just doing it for estate planning purposes. How does that actually work?
And most of the time it's for a company. I mean, typically it's a family business and they put the business in the family limited liability partnership, or now more common family limited liability company. But it can be done with any asset. It doesn't necessarily have to be a business. And it has two benefits. One is, as I said, asset protection. So if I am a member of an LLC or a limited partner of a limited partnership, and I get sued and I get a judgment against me, the most that my creditor can get is a charging order against the LLC or limited partnership, which allows them to seize distributions made to me by the LLC. They stand in my place as a member with regard to distributions. They can't take my membership interest or my partnership interest. They can only get a charging order as to distributions. Well, there's no requirement the LLC make distributions or pay them out. They can keep them in. And that can have bad consequences for my creditor because they get taxed on my distributions, even if the distributions were not made. So they're going to get a 1099 or a K1 that is is going to put them on the hook for the distributions. It's a very powerful tool that wealthy families use for that reason, to protect all the kids and everything from creditors. With a typical family company, but also with just wealth, I mean land or whatever, it all goes in there, and stock and bond holdings. The same asset protection is achieved, and in addition, the parents can start gifting membership interests or partnership interests to their children every year and their grandchildren, so that, and if those interests, which if it's a company, are deeply discounted over what the real value would be for that company, over time, much of their wealth will have shifted to the children, and by the time the parents pass away, they will be under, let's say, the $22 or $23 million lifetime gift and estate tax exemption for a married couple. It's very effective.
Got it. And in that sort of slow amortization of shifting wealth from parents to children, that can be accomplished outside of the reach of, creditors, for example. And as we were discussing a moment ago, is that accurate? Absolutely.
Whether you use irrevocable trusts to do it or use a family limited liability company or partnership.
And so the scenario of like the Apple stockholders has a bunch of Apple stock, they can create a limited partnership or an LLC. It doesn't really it's not meant to conduct a business as such. It might have some ancillary revenue, such as from dividends, but you could use that instrument, it sounds like, for just the purpose of asset protection, and eventually maybe transferring your wealth to family members, even though it's not in itself a business. Is that correct?
That's correct. There's no requirement that there be a business in that limited liability company.
Have you found that in your past experience, clients who transfer money into an irrevocable trust, is a common strategy to do that at the moment of death rather than during their lifetime? Well, just so that they retain that control during their lifetime, but then at death, then immediately it pours over into an irrevocable trust?
That doesn't get the asset protection that they would have had during their lifetimes if it had been an irrevocable trust. But as a practical matter, every revocable trust becomes irrevocable on the death of the grantor.
That's true.
Yeah.
So it doesn't get the asset protection due to the fraudulent conveyance rule, or because that's just the way the law is?
Well, because while it's revocable, it's considered your asset. So as long as you put assets into a revocable trust, the revocable trust is disregarded for asset protection purposes and tax purposes.
But if you poured over assets in your will into an irrevocable trust, it sounded like you were saying that doesn't actually accomplish asset protection.
So that's interesting. So in the hypothetical, let's say I have a son. I'll use him as the example, and I'm instead of leaving to him outright, I'm leaving to an irrevocable trust that he's the beneficiary of.
Yeah, because maybe my goals are asset protection and I want to avoid probate at the same time.
So yeah, in that situation, you would still have to probate. Well, so my irrevocable trust pours over into my revocable trust pours over into a new irrevocable trust for my son. Is that what's happening, or am I?
Or I assumed you could just pour directly from you, I guess, using your will. So the will have to be probated, but upon your death, all the assets just go immediately into an irrevocable trust with no intermediate step. Is that possible? I assumed it was.
No, not really. If I own them in my own name, they'll have to be probated. And during the probate, my creditors can attach. Yeah.
Gotcha.
But of course, his creditors, if he's the beneficiary of an irrevocable trust, he would be protected from his creditors. So let's say, for example, my son has giant judgments against him, and I know that he's, not going to pay them off. I could do that. I could say in my will, my will can create a trust. We call testamentary trusts. So I can build a trust into my will and say, upon my death, all of this is going to go to the Spiro Jr. Irrevocable trust. With Uncle Bob as the trustee, and so his creditors will not be able to touch that asset. He will be the beneficiary of a trust, but he'll never own the assets outright. And so that's an option that people do that actually frequently in their wills when they have a child that has tremendous debt.
Got it. Let me actually ask a derivative of this, which is, instead of doing a pour over, if somebody who is expecting death, they don't know when, but they know it's coming soon, maybe because they're in hospice care or something like that. if they create an irrevocable trust prior to death, and they transfer all their assets in, as long as they don't run afoul of any fraudulent conveyance rules, that would that allow them to accomplish the goal of, maintaining control and ownership during their lifetime, but only shortly before death, transferring everything for asset protection and avoiding probate purposes?
Yes, and that's not uncommon. I mean, I've had people who, had to go to the ICU uh, to set up their trust. That they wanted to get it set up and funded before they died. So they're signing deeds, putting real estate in the trust. It happens. It happens. As long as it's not a fraudulent conveyance, there's no problem with doing that.
Got it. Okay, great. So wrapping up here, I would love to kind of get your quick thoughts. Maybe we can just treat these as quick hits, of just to give folks a flavor of the type of estate planning instruments that might apply to different personas. There's lots of different types of trusts that you can create. As you mentioned, some are very common, others are more obscure, and what's right for you depends on what your estate planning goals are, your level of wealth, maybe even what state you live in. And I was just kind of curious to get, quick reactions on what are the types of trusts that you might potentially advise for, high earners or high net worth individuals. Let's say you're advising the following personas. So like number one would be an early retiree, 30-year-old, married, no kids, say $3 million net worth, and they're really just trying to accomplish wealth preservation and facilitating a smooth transition if they pass. Any quick thoughts on likely appropriate trust instruments that would benefit them?
Yeah, in this case, they're not concerned about what they pass on to the next generation. They're just focused on, I presume, asset protection during their lifetimes. So they could create an irrevocable trust, make themselves the beneficiary of it, and they will be provided for the rest of their lives. And if their creditors would not be able to touch that money.
And if they wanted to make sure that those assets could pass smoothly to a spouse?
They could both be beneficiaries of what you can do is they're both beneficiaries. The grantor creates the trust. There are two beneficiaries. The spouse should be able to get the money when the grantor dies.
Okay, great. Second persona, so like a high earning professional, 40 years old, married, 2 kids, dual income, say both spouses are earning 6 figures. Maybe they have half a dozen rental properties with mortgages still on them. Also, they have $3 million in net wealth when you net everything out. And maybe their estate planning goals are wealth preservation, asset protection. They would like to avoid probate and facilitate a smooth transition to their heirs or their beneficiaries if they pass. What are initial reactions on what might be appropriate for this profile?
So in this case, I think the typical solution would be a revocable trust, a joint revocable trust for the two of them. And I would make the trust the sole member of LLCs to own each of the rental properties. And I think that would they would avoid probate, they would facilitate a smooth transition, and it would preserve their wealth from potential liability arising from the rental properties.
Gotcha. All right, third persona, say a high earning business owner, 40-year-old, married again, 2 young children. They own a successful family business and their household income overall is now 7 figures. Maybe the one spouse doesn't work. They have $10 million of net wealth and say a primary residence worth $1.5 million. And their ownership stake in their sort of closely held family businesses is illiquid. And their estate planning goals are similar to the previous scenario, but they also want that business continuity. They'd like to avoid taxes as much as possible at death. And just like providing income security for the non-working spouse in case it's the working spouse that gets hit by a bus.
So this is an interesting case. They're below the threshold for estate tax considerations, so that would not be an issue. Although politically, who knows what's going to happen? The estate tax exemption recently doubled, so it could be halved in the future. Putting aside estate tax considerations, and I should add that many states have inheritance taxes and estate taxes of their own. And you have to check at the tax situation in your own state. Florida has no inheritance or estate tax, so our only concern here is federal taxes. They own the closely held business, so and it's illiquid. So that should probably be in a family limited partnership or family limited corporation. That would be a classic example. It would be, and if state tax laws did change, it would be a great vehicle for minimizing their exposure there. Otherwise, I would see, and I would also protect them from personal liability arising from the business. Otherwise, I think I would, again, just use a revocable trust for this family and, entitle the assets other than the business to the trust.
Got it. Okay, great. And the last persona I have is, say, a 60-year-old married retiree, very large stock option windfall from their former company's IPO, 2 adult children, 2 grandchildren, $30 million in net wealth, half of it still in company stock, and a $7 million primary residence. So they're doing pretty well. In this case, their estate planning goals really are wealth preservation and true tax minimization, providing income security for, spouse, safety net for their children without encouraging dependency, I guess. They want their children to make an effort, but they also want to provide a safety net. What might be appropriate? And I know this can start to get complicated, but at least any initial reactions?
So there are a number of things you can use to reduce their estate tax liability. I would start with the residence. I think a qualified personal residence trust would make sense for this couple. It's a technique basically that you use to take the house, if you have a very high value house, out of the estate for estate tax purposes. The other thing that they might consider to sort of simplify things is an ILIT, an irrevocable life insurance trust. It's a way that you can actually prepay for your expected estate tax exposure. The problem with life insurance is that it's an estate asset, but an irrevocable life insurance trust allows you to take life insurance out of the estate, not have it, because it can be self-defeating. If I try and take out a life insurance policy to cover my estate tax liability, the proceeds of my life insurance policy add to my total taxable estate, but not if you have an ILIT. So that might be a simple way to handle this for this couple. And that would also, you could do it on first death possibly, or partial payout to make sure that there's plenty of liquidity. With regard, I would again put them in a traditional trust. And this is an issue many of my high net worth people suffer from. What do you do to avoid making your kids, not incentivized to work? The worst mistake that I've seen over the years is the monthly income approach, or the annual income approach. If they're just getting $300,000 a year from the trust, it disincentivizes hard work. What most people choose to do is an incremental payout of wealth, or sometimes, and they can kick the can down the road by basically not allowing the kids to get more than a certain amount, and then giving the kids perhaps the power of appointment with regard to their share, so they can decide what happens with their kids and let it go down the estate. Because I frequently am involved in some probate litigation right now involving a family that 3 generations ago had banking wealth from upstate New York. And as the family has grown, the amount that everybody gets has shrunk, but it's still pretty substantial. And nobody in this family has a job. I mean, and all they're doing is fighting about what share they get of the last person to die. So it's a real problem. And I prefer the chunk approach, like when you turn 50, you're going to get $1 million or something like that. But rather than I'm going to provide income for the rest of your life approach. Troubling. But it's a very personal decision. And I like to get the whole family involved, including the kids, typically, so that everybody's on the same page about it, because it's a generational, it's going to continue. Like, what do you do with the grandkids? If you have that amount of wealth, it's going to be a situation that you're dealing with for decades and decades to come. Got it.
Any other potential techniques that might apply to this scenario besides the qualified personal residence, the irrevocable life insurance, and potentially the chunked approach?
Yeah, there are grits and grats, different types of irrevocable trusts, grant or retain interest trusts, where basically you're creating an irrevocable trust but controlling what it's doing for the rest of your life, and all of that. But they're not rich enough that I would overcomplicate their lives with irrevocable trusts. If it were an order of magnitude wealthier, then perhaps. But this couple, even if they did nothing, the reason I said the ILIT, because even if they did nothing, their taxable estate would be $7 million. And if we did a QPERT, it would be 0, because if the house is $7 million, we just addressed it by putting it in the QPERT. If there were any excess, I would use an ILET, because the problem with irrevocable trust is it does become kind of a management issue. I have a client who had their CPA handling all of their irrevocable trusts, and he's now out of the picture, and we're trying to figure out what's happening with all these irrevocable trusts. We don't have the records, and then it's chaotic. And so it can become very complicated. I'd like to keep my clients' lives as simple as possible. And so for a $30 million wealth couple, I would do a QPERT and or an ILET, and allow them to maintain some flexibility over their wealth and simplify their lives.
Okay, perfect. Hey, Spiro, this has been really informative, insightful, and a lot of fun. Where can people find out more about you and your legal practice and services?
Thanks, Andrew. It's been a lot of fun for me too. They can visit my website. It's verraslaw.com. That's VERRAS-LAW.com.
Okay, perfect. We'll definitely link to that in the show notes. And thanks so much again for taking the time to chat with us today. Look forward to sharing this with all of our listeners.
It's been a pleasure. Take care.
Cheers. Take care.